Hello, and in the third of our briefings on developments during the COVID period, I'm joined today by Richard Palmer, who heads the Restructuring and Insolvency team at Kuits Solicitors in Manchester. Richard, can you tell us a little bit about the type of work that your team does?
Yeah, hi Robert. It's a wide area in the restructuring and insolvency team. We act for a number of different types of clients. The core clients are insolvency practitioners on legal issues that arise in their appointments. So that might be assisting with sales of assets or pursuing claims they might have. The second core type of client is lenders on security, reviewing and enforcing security. There is a substantial overlap between security enforcement law and insolvency law, so get involved with some of them. The third core type of client is directors and companies, where they have duties and obligations, and if the directors have any concern about the solvency position of the company or require some advice on assistance of sales in a distressed situation, we can assist with those to try and make sure they're as compliant as possible with the insolvency legislation. We can also act for individuals and other stakeholders where insolvency is an issue. So a creditor, a landlord, if a tenant can't pay, suppliers, if customers enter insolvency, we can act in that sort of situation as well.
And how has COVID-19 impacted on the work you're doing?
With companies, there's two different issues at the moment. In the retail sector in particular, larger companies in certain sectors are using insolvency processes. So a number of high-profile retailers have entered administration during and since the lockdown. As we slowly emerge from that lockdown, a number of others are considering restructuring their obligations to the landlords in particular through company voluntary arrangements. This has had an impact on property investors in particular, who will lose out on rental income that's agreed under leases. And it may impact the covenants they have with the lenders. Although so far, lenders seem to be taking a really constructive approach towards these property investor customers of theirs. With SMEs, there's not yet been any spike in insolvencies. Government support that's been provided to all companies has really helped the cash flow of companies through this time, in particular furlough schemes and VAT deferment schemes. There's also the availability of the C-bills and bounce back loans, and also enforcement steps that people can take have been stymied somewhat with the moratorium on forfeiture and the substantial narrowing in the use of winding up petitions. So for the time being, there hasn't been a spike with SMEs, although that may change.
And we're reading a lot, in particular this week, about the Corporate Insolvency and Governance Bill, which I understand is set to pass this week, I think. How's that going to change things?
That bill is going to bring a radical change to the insolvency laws of this country. There's a number of measures in it. Some are temporary and some are permanent. The most important temporary measure is a substantial narrowing in where winding up petitions can be used against companies. Presently, I believe until September, that there's going to be that significant restrictions on the use of petitions, but I wouldn't be surprised if it was extended beyond that. Petitions will become much more costly for creditors to use. There's going to be at least one extra hearing on every single petition. That's to verify that COVID hasn't had an effect on the debtor. And evidence of the debtor's financial position is going to have to be considered in practice in all of those cases. So I think that's going to make winding up petitions much more costly and much less certain than they have been in the past. The most important permanent change to suppliers of goods and services is probably that they will no longer be permitted to terminate supply contracts on the basis of the customer entering an insolvency process. But I'd urge suppliers to take advice from commercial lawyers to preserve their position as much as possible, either now or a bit later on if they get wind of concern about a particular customer. The most important change to the restructuring industry is that the new insolvency procedure is going to be introduced called a moratorium. The moratorium is designed to give companies breathing space to formulate and implement a rescue plan by giving companies a payment holiday on many debts that have accrued before the company entered the moratorium. If creditors consent to a moratorium, the moratorium could last for up to 12 months. This could be a really useful mechanism in the restructuring industry to enable companies to ultimately repay liabilities they owe.
And we're hearing a lot about wrongful trading. I hear from company directors that they're worried that after all this passes, that the authorities will be picking over decisions they've made during the COVID period, which was, of course, an unprecedented period for their businesses, and somehow suggesting that they've acted wrongly with consequences. Is that a legitimate fear?
A director in normal times can be held liable to contribute to the assets of the company if they're held to have committed wrongful trading. In its simplest terms, wrongful trading is where a company trades on past the point of no return and worsens losses to creditors. Back in March, the government announced that it was going to suspend wrongful trading for this period. I thought that announcement was good politics, insofar as it gave a message of comfort to directors concerned about their position at this time. In practice, wrongful trading is not very commonly pursued by liquidators. There's a fairly high evidence threshold, and lots of evidence is required for such a claim to be successful. But the risks to directors at this time, in my opinion, are very much on other transactions and conduct. Two examples that very much relate to SMEs. Firstly, it's very common in small companies for directors to take loans from those companies and award dividends at the end of the financial year out of distributable profits. There's tax benefits to directors in doing that rather than taking PAYE, which is fine if the company is profitable. If the company becomes insolvent and directors have done this, that becomes a problem that the directors will need to deal with upon an insolvency. The second issue is the reverse position. If director puts money into a company as a loan and repays the loan, if that is done in the 2 years before the company formally enters insolvency, it may be deemed a preference and so may be recoverable by a liquidator. So in short, as I say, I think wrongful trading isn't necessarily the worry, although there is a duty on directors to act in accordance with their duties. I think it's more the general transactions around that directors can enter into that they should be worried about in practice.
And does it help if that situation were to arise? So if there were a subsequent insolvency, and if someone was a liquidator, say, was picking over the bones of things that had been done by the directors before the insolvency event, does it help if someone has taken professional advice before doing these things?
In short, yes. I mean, each case is unique, but the basic legal position is the same. Directors have a duty to act in the creditor's interests at a time where the company is or is likely to be insolvent, and that's on either a cash flow basis or a balance sheet basis. Balance sheet basis is particularly important at this time because I mentioned before about C-bills and bounce back loans and VAT deferments. Those liabilities are ultimately going to have to be repaid by the company, and they will sit on a company's balance sheet, even if there are generous time to pay arrangements or a long term for repayments of the loan. So that's something that directors need to consider in assessing whether a company is solvent or not. There are three absolutely basic fundamentals that will apply in each case. I think directors need to ensure they've got access to good information, in particular financial information, to assist in making their decisions. They also need to communicate with key people in the company and the key stakeholders, such as creditors. They need to find out what they are thinking to assist with the decisions that they will take. And recording what is done and why it's done and how that's in the creditor's interests, that I cannot emphasize enough that directors should do that. In terms of getting advice, both financial and legal advice are really helpful. Court will consider that director is discharging the duties seriously if they're getting professional advice from those that are in a position to assist.
Thank you, that's helpful. So we've spoken a lot about companies. What about individuals?
Individuals, the legal position hasn't changed insofar as there's been no effects on whether creditors can initiate bankruptcy proceedings against individuals. Individuals are going to be entitled to some of the reliefs and deferrals that companies are if they are trading, and they also will have less formal remedies to help, such as mortgage holidays and credit card holidays and so on. But ultimately, with individuals, the legal position hasn't changed.
So the $64,000 question, when will there be a spike? Will there be a spike? Or do you think, government action be successful in, I suppose to use a well-known phrase at the moment, flattening the curve in terms of insolvencies?
It's hard to say. I mean, I would expect the number of insolvencies to increase, and probably from autumn this year. I mean, if we use the leisure sector as an example, in the short term, the ending of the furlough scheme is going to put significant employee costs back onto companies at a time where substantial numbers of companies in that sector aren't going to get the footfall that they got before. So they might not be able to generate income to cover all of their costs in full. Government restrictions and consumer confidence are going to be relevant to that. So I do foresee problems in that sector if companies cannot restructure their workforce and reconfigure their premises and outdoor spaces to increase their ability to supply services to customers. My second concern applies to any company. I mentioned it before. It's the ultimate requirement of companies to repay liabilities. Many will have been deferred and will be sitting there for many years to come. So it could well be that many more companies than before are balance sheet insolvent for some time. That could have an impact on bank loans, on getting credit. And that's something that directors, I think, need to look at very carefully going forward.
So generally speaking, in terms of companies which may require assistance in making the decisions they're having to make now, from those on the one hand to companies which are already finding themselves in financial difficulty on the other, to I suppose also companies that have concerns about their suppliers and or customers who may have financial problems. That's the full range of advice that you're able to give, is that right?
Yeah, I'm able to help companies in those situations, together with colleagues as well. I mentioned supply contracts. The commercial team are well aware of the changes that are coming in the corporate insolvency bill. Yeah, I believe that we are able to assist anyone of those categories who needs any help.
Okay, well, your details are going to come up at the end of this discussion. I'm guessing you're perfectly happy for people to call, ask quick questions, get a flavour for what the position may be before they commit to a course of action. Is that right?
Absolutely, and I would urge people to do that. I think it's a fast-moving scene at the moment. The Corporate Insolvency and Governance Bill having its third reading today, in fact. So the law is going to change imminently. So I would urge anybody who feels the need to just pick up the phone, chat things through. More than happy to assist.
Okay, thank you, Richard. That's extremely helpful. Thanks for that. And until next time, we'll be returning with another briefing soon. Thank you.